So the state, aka the feds in California, said, "Oh, that's what y'all coming with? Well, we got something for Durk too." So, hey, here's the whole entire thing. I didn't really react to it in real time. I did in some, but in this instance, we're going to get at the end of the video so y'all can hear it all. And then I'll show y'all where the feds were right in their argument, but also where they was wrong in their argument. And you know I'm finna send a couple of emails to my people over there, because one thing we not doing is we ain't going. So, hey, man, if you can, hit the like button like you like something, subscribe. The only place you can come to for this news when it drop, we give it to you like Snoop Dogg, drop it like it's hot. Let's go. All right, man, here we go. So this is Durk right here. This is government's opposition to defendant's bank's application for reconsider of detention order. So we ain't even finna read all this stuff. You already know what they talking about. We finna oppose him getting out. And here's what they said. Memorandum of Points and Authorities Introduction. Defendant is charged with directing 6 hitmen to travel across the country to hunt and kill his rival, TB. That's Quando Rondo. Defendant allegedly orchestrated and financed the brazen murder plot that culminated with shooters ambushing TB's vehicle at a busy gas station in broad daylight, killing SR. That's Lil Pop. Following a detention hearing in December 2024, the court ordered defendant detained based on flight risk and ongoing danger. Pay attention to that ongoing danger part. They ain't put that in there for no reason. It reasoned that no conditions of release would reasonably assure the safety of the community, finding that defendant uses his money, influence, and power to endanger individuals whom he perceives as a threat. DTK 116 at 4. The court also found that defendant was a flight risk based on his attempt to flee the country immediately after learning of his co-conspirators' arrest. Defendant now seeks reconsideration of that order. But defendant's application fails to address, and I said this before, y'all, any facts that the court relied on when it made its flight risk and danger findings, and fails to present information that was not known to defendant at the time of the hearing and that has a material bearing on its dangerousness in Flight 18 U.S.C. 3142 F2, emphasis added. Instead, he offers essentially the same bond package the court already rejected and seeks to relitigate an immaterial issue about when certain of his violent rap lyrics were written. Indeed, the crux of defendant's application is that he did write lyrics about greenlighting someone's murder, just that it wasn't this murder. But, man, whatever, okay. But the timing of defendant's lyrics and whether or not he commercialized his violence through rap, which he did, has little to no bearing on the detention analysis before the court. The issue here is a narrow one. Has defendant presented new information not known to him in December 2024 that has a material bearing on whether he should be detained pending trial? The answer is no. The government respectfully requests that this court summarily deny defendant's application for reconsideration. Background. The indictment and defendant's attempt to flee. On October 17, 2024, a grand jury sitting in the Central District Court of California returned an indictment charging five of defendant's co-conspirators with crimes arising from the murder. So what happened to the sixth one? Including murder for hire and conspiracy to commit murder for hire resulting in death in violation of 18 U.S.C. 1958A. CDKT. Defendant was identified as co-conspirator 1 throughout the indictment, which listed defendant's involvement in the murder scheme, including the allegation that he told co-conspirators that he would pay a bounty for TB's murder. CID at Overt Act 1. In the early hours of October 24, 2024, federal and local law enforcement executed multiple search warrants at locations associated with members of defendant's organization, Only the Family, or OTF, in the Chicago area and arrested the 5 charged co-conspirators. Soon after law enforcement executed the warrants, the FBI learned that defendant had been booked on 3 international flights, including at least 1 to a non-extradition country. Defendant skipped the first 2 flights and was arrested when he showed up to board a private jet scheduled to leave the United States a short time after. ID at 9 through 10. On November 7, 2024, the grand jury returned the first superseding indictment, FS1, or FSI, against defendant and his co-conspirators. The FSI identified defendant as co-conspirator 1 and alleged that he formed and was the leader of OTF, a group of individuals who engaged in violence, including murder and assault, at the direction of defendant banks and to maintain their status in OTF. ID at introductory allegation 1. The FSI also included an allegation that defendant commercialized his violence through rap lyrics. Defendant is ordered detained. In December 2024, the court held a detention hearing and considered evidence and arguments submitted by the parties. Among other things, defendant made the same argument he now raises in his application to reopen, a claim that the lyrics cited in an introductory allegation in the FSI about greenlighting violence could not be about SR murders because defendant wrote the lyrics before the murder occurred. During the hearing, the court addressed the matter, finding that the consistency and timing of the lyrics has some relevance, but marginal to the dangerousness issue, which is the issue before me today. After considering the evidence, the court ordered defendant detained based on flight risk and ongoing danger to the community. The court subsequently issued a thorough written detention order. As to danger, the court detailed the allegations against defendant, including the co-conspirators acting at defendant's direction, traveled to Los Angeles, tracked, stalked, and attempted to kill TB by gunfire, including a fully automatic firearm in broad daylight in a busy Los Angeles intersection, and did kill a family member of the target who was traveling with him. The court also relied on evidence that this was not defendant's first murder-for-hire plot, noting, in a separate matter in Chicago, defendant is alleged to have engaged in a similar conduct. That is, the offered money for people to kill those responsible for his brother's murder. And more specifically, offering to pay money for any gangster disciple that is killed. That's not even true, though, because he had a couple of GDs signed to him. That doesn't even make sense, but whatever. As a result, the court found the material proffered by the government supports the conclusion that defendant uses his money, influence, and power to endanger individuals whom he perceives as a threat. Government's detention brief, example 2, under seal at 12:14 through 15. As to flight, the court rejected the argument that defendant's significant bond package mitigated his risk of non-appearance. Among other things, the court found that defendant attempted to leave the United States upon learning of the arrest of his co-conspirators. Argument. Defendant's application fails to offer any new evidence, much less evidence that is material to the detention analysis. A detention hearing may be reported only if the judicial officer finds that information exists that was not known to the movant at the time of the hearing and that has a material bearing on the issue, whether there are conditions of release that will reasonably assure that appearance of such person as required and the safety of any other person and the community. 18 U.S.C. 3142 F2 emphasis added. Courts have interpreted this provision strictly, holding that hearings should not be reopened if the evidence was available at the time of the initial hearing. See United States versus Dillon, and then per claim affirming district court's refusal to we ain't finna do all that. Here we go right here. As to materiality, to open a detention hearing, a defendant must proffer evidence that, if true, affects the outcome of the court's pretrial detention inquiry. Here, defendant's only proffer of new information is that viral video, which overlaid the news clip of SR's death on top of the defendant's songs, including lyrics about greenlighting a murder, were made by defendant's fans, some of which have millions of views, not defendant. But defendant's claim about the timing of his rap lyrics and the fan-made videos is neither new nor does it have a material bearing on the court's detention analysis. Tellingly, defendant's application does not even reference the court's analysis on danger or flight. It actually does, though. But you just lied, but that's, y'all do that. It does not explain how defendant's lyrics or fan-made videos undermine the interference that defendant, who has considerable resources, attempted to leave the United States upon learning of the arrest of his co-conspirators, or that defendant uses his money, influence, and power to endanger individuals whom he perceives as a threat. Nor could it. At the hearing, defense counsel raised the exact issue of timing of defendant's lyrics. The court made clear that the lyrics were not material to his detention analysis. So Drew gonna try to have that knocked out there. He'll try to throw that away, because if you're saying that that's not even material, like that's not important, then Drew gonna say, then why bring it up? So here you go. The lack of materiality is confirmed by the court's oral and written explanation of his detention order, neither of which considers or even mentions defendant's lyrics or the above referenced videos. We're gonna go back to right here, and it says CEG, Lil Durk, Dis Quando Rondo, a new song, and then it says Lil Durk, King Von, Quando Rondo available, and then it shows the YouTube video, and the lyrics defendant challenges are contained in paragraph 6. So basically, they're just showing the YouTube video. So they didn't even reference the YouTube video in Drew Finland stuff. So, yeah. Moreover, defendant's proffer that his fans, rather than defendant himself, created the video linking him to SR's murder is immaterial to defendant's danger or fight. Defendant was not detained because of videos his fans created. He was detained because he is alleged to be the leader of a violent organization, because he orchestrated and funded an execution-style murder with machine guns at a busy gas station, and because he tried to flee the country after his co-conspirators were arrested. But that's not okay. Drew gonna argue this, but I'll kind of explain it a little bit. But even if the lyrics or the videos had some bearing on the detention analysis, they corroborate defendant's danger. Defendant has repeatedly used his pulpit as a voice of violence, publicly rapped about paying for murders, hunting opponents with machine guns, bounty hunters in Beverly Hills, and other lyrics that have a striking similarity to the modus operandi. operandi, I'm sorry. Yeah, to the modus operandi used to kill SR. As the court found in ordering defendant's detention, defendant uses his money, influence, and power to endanger individuals whom he perceives as a threat. Defendant is wrong to suggest he is charged. For example, defendant was featured on another artist's song in which he raps, "I don't want no niggas who you catch. I want the one I paid for. Trolling ass, we shot your homie. Gucci Mane, rumors." In this case, or is being detained pending trial because of his lyrics. It's true that words have power, and defendant's words about greenlighting violence and placing bounties may be admissions of criminal conduct. That is for a jury to decide. But this case is not about how defendant made his money. It is about how he allegedly chose to spend his money and wield his power in August 2022 on death and violence. Conclusion. For the foregoing reasons, the government respectfully requests that this court deny the application and maintain its order detaining defendant pending trial in this matter. So, first questions that I seen, right, was this. Hey, bro, why didn't Drew basically lay out the plan of how they gonna perform and how they gonna attack and all that stuff and everything? And then I got something else for y'all too. It's gonna be good. How come he didn't do all that? Because he has to wait until trial to reveal his head. Remember, all the stuff that the feds have, they had to give it to the defense. But the defense plan of attack, they don't have to. All they have to do is let them know of witnesses that they plan on calling, and then, you know, the stuff that they're going to introduce and everything, and then make sure that they are good to go. So you're going to have motions to get rid of evidence. But, bruh, so the feds basically said that the lyrics are immaterial. If the lyrics are immaterial, meaning if the lyrics don't really matter, then why the hell did you bring them up in the first place? You're just piling on. That's like saying, hey, bruh, I just ordered a sundae. All right, yeah, you ordered a sundae, but what else you get? Oh, yeah, we got the fudge on there. All right, cool. Is this sundae perfect? Yeah, it's perfect. Yeah, but sprinkle some nuts on there, too. Yeah, put the cherry on top. But if it was already good, why'd you need the extras? See, what they're trying to do, and I told y'all this, and I keep on telling y'all this, the feds like to pile up and it's death by 1,000 cuts. The feds know what the hell they doing. You know what the feds didn't do? They didn't address what Drew said at all about the flights. Drew has to go in there right now and basically show that Durk is not a flight risk. That's it. If what Drew said, if he has a pattern of history of Lil Durk, because that's literally what he said. I'll pin the other video, or I'll put it at the end screen and then y'all can look at it. Drew basically said, this is how he's always bought the damn tickets. Then Drew also made the point, hey, bro, y'all do know that y'all snatched his phone. The Fed seized Durk's phone, and Durk didn't leave the country immediately after. So what are you talking about? To me, just to me, that's the point right there. He got nothing to hide. You see, one of the things that you know is sometimes the feds tip their hands. The feds tipped their heads when they literally took his phone in Chicago and didn't get on his case for a couple of weeks after, or I think it was like a couple of days after or whatever. I don't remember the specific timing of the show. So anybody who reacts to this, please make sure you put that in there. So yeah, bruh, the timing of the show, he should have left immediately afterwards. That would have been the panic right there. But Drew said, and Drew's going to have the facts of it, he books flights the day of. So what are y'all talking about? Drew's argument is going to win, but the issue at hand, and I'll react to Durk popping up on Loose Cannon's channel probably tomorrow or maybe tonight. I don't know. Y'all let me know on that one. I real life want to drop it tomorrow so I can thoroughly go through it, because I know there's going to be hits and misses in that interview. I didn't get to watch it yet. I want to react to it in real time when I listen to it. So shout out to y'all who was like, Seti, react to it. I got y'all. Just wait. But also, the feds said Durk is so dangerous, right? The feds never even say, and this is what I thought they were going to do. If I was the feds, bro, I would say, hey, Durk already knows the witnesses. He's seen all the whatever. He's seen all the evidence. So that would mean Durk hasn't seen evidence, because I'm fairly certain they would have brought that up. So Durk doesn't even know the witnesses that we think he do. Remember when we were hearing, oh yeah, people were getting shot in Chicago and people were dying and they were about to testify and all this stuff? Feds never said that at all. The internet made up that story. So when it boils down to it, Feds wrong. Y'all said the lyrics don't matter, so get rid of them. You didn't. Y'all said, oh no, it just talks about how he is, but y'all couldn't even link the lyrics to his brother's death. So there's that. So they're making that up. That's not real. That's fake ass news. The feds are lying. You can't say, hey, bruh, because he rapped about it years before it happened, he just forecasted that that's how he get it done. How in the hell did he know, and how the hell did they know that that was going to happen? Then y'all try to fake link Durk to the shooting that happened with Quando Rondo while he was at the gas station. Did Durk ever make a song about something like that? No. Now, if you believe Durk is guilty beyond a reasonable doubt and everything, you want to say I'm capable for him and all that, that's cool. I'm not mad at y'all who get mad at me for these type of things. Now, I will say this. I don't think Durk is going to get a bond. I just don't. But I hope I'm wrong. The reason I don't believe Durk is going to get a bond is simply because of this. They're saying that your power, your money, your influence is something that will get everybody killed. That all you have to do is snap the finger and everybody dies. True Feeling can't really put it out there like that as to why that's BS, because that gives the feds leverage. You see, he's still going to trial no matter if he gets out on bond. So we had to factor that part in when we're thinking about it. Are the feds wrong about the lyrics? 1,000,000%. They do this shit all the time. So the question is, what calls were intercepted? What text messages? And what are witnesses going to say? Somebody is going to flip on Lil Durk. It just is what it is. It's going to be on Drew or whomever in which he has cross-examined him to destroy the inconsistencies, which he will do. I'm not saying nothing that Drew going to be listening and be like, oh, yeah, I'm going to do that. No, this is the game plan, because it's always been the game plan, because this is how you do it. You destroy the inconsistencies in the story, and then you point out the motivations. Because what the feds won't do is they won't say, oh yeah, we're going to cut you out right here. But we all know the feds, when you snitching, you're getting 33% of your time cut any damn ways. So there's that. But add it with this, and this is the biggest thing I need y'all to take away from this. Lil Durk, right now, as it stands, has a good chance. But we don't know what we don't know. There's a reason they dumped all those terabytes at the last effing minute, and while the judge decided to grant him a longer stay at that detention center. Remember, Durk's trial was supposed to already happen, and it hasn't. It's pushed back to like November or something like that, or October. I'll be there, that's a little bro. I got to support him. But this type of stuff right here, the feds play dirty, and they know it. That's why Drew put so much emphasis on those lyrics being wrong, because what Drew needs the court to do is to find out that the feds were wrong twice. And if they were wrong twice right there, that's enough. The feds are full of bullshit when they say, oh, well, it still doesn't address the matter at hand. Yes, it does. Y'all say he's a flight risk. That's part of y'all argument, is he figured out everybody else going to jail. I'm guilty because I know I had a part in this, so I'm going to run now. They already got them. I got to run now. Yeah. Y'all thought come on now. That's their argument. Part of what they're saying is he's guilty from trying to run. If that part is not true, that's a huge W in this case. So we will see. But y'all, I'm looking forward to reading y'all comments on this one, man. Share to keep your people aware, subscribe, turn on that bell, stay notified, and I'll catch you on the next one. The Young L. Well, hold on, I ain't even finna do all that. There was a your boy Snoopy Badass decided to respond to me. I'm just gonna say this. I'm not responding to you, bro. You ain't big enough for me to respond to. I'm damn near probably gonna make more views off of off of your little clip that I put on my channel than you actually did on No Jumper that has millions upon millions of subscribers. I'm not finna dish you, bro. In real life, bro, that energy that you have on the internet, I doubt you have it with me. I'm just gonna be fair. I'm not challenging to no fight or anything like that, but nah, bro. So have a good one. I wish you well. I wish you high success. I hope that you get your Vlad TV interview. I hope you do everything that you say you want to do. I hope you get your bread up. I hope all of that. But when you talking about somebody that I know, yeah, it's cool. But what you did was foul and what you did was wrong, in my opinion. You disagree, But anyways, click right here, hit the playlist right here, and then here's the Durk video from Drew Feeling that I was talking about. I'll catch you on the next one.